The House Judiciary has written a letter to Merrick Garland urging him to take action on SB 8 in Texas. And before I read you this letter, let me just read you something I tweeted out today. And I want you to know I'm still a Merrick Garland defender. I disagree with him on some things, and I will voice those things. And sometimes when we voice those things, we get some movement. But I still do not prescribe to the we must have him fired or he must resign school, or that he's just completely incapable of doing the job. There's still too many things that we don't know what his decision is on yet. Do you know what I mean? We don't know if he's going to refuse to prosecute obstruction of justice. We don't know if he's, going to refuse to investigate or prosecute the leaders of the insurrection. We already know he is investigating that. And there's been a lot of proof of that in court filings and 302s. So I'm not an all or nothing, but I will definitely criticize him where criticism is due. And my tweet today, if I can just pull it up here, because I'm also biased. I'm also very angry about what's going on in Texas. And that's okay. I'm allowed to be.
Absolutely.
So, holy crap, I tweeted a lot today. Scrolling. Keep those scrolling. Here we go. Oh, nope. That's what I want to hear from Biden on the COVID stuff, which I can tell you. Here we go. I say, I do not get it. I have been a Garland defender for a while, but how can the Justice Department file that weak-ass legal argument to appeal the release of the March 2019 Barr memo, but not sue over SB 8? Put on your original jurisdiction pants and ask the Supreme Court to repeal SB 8, or at least try. And my point here is the legal arguments that Merrick Garland put forward. Well, it wasn't actually Merrick Garland. It was somebody else in the Department of Justice, but it came from the Department of Justice. The legal arguments he put forward in the case to withhold that second half of that Barr memo were weak compared to Judge Amy Berman Jackson's legal reasoning. They weren't good. I don't think he'll win. And it was kind of a crap argument. So it seems like the Department of Justice is willing to give things a shot. So I don't understand why he doesn't just try. I think that they actually have a lot better legal argument in this case against SB 8 than they did in withholding the second half of the Barr memo. Anyway, let me read from this letter. Now, the letter is addressed to the Honorable Merrick Garland. It says, Dear Attorney General Garland. So it's not the Department of Justice. It's to Garland. We write to ask you to use the full power of the Department of Justice to defend a woman's constitutional right to choose an abortion, and right now under assault by Texas Senate Bill SB 8. Because the department cannot permit the second largest state in the nation to deprive women of their constitutional rights by outsourcing the enforcement of SB 8 to private individuals, we urge you to take legal action up to and including the criminal prosecution of would-be vigilantes attempting to use the private right of action established by that blatantly unconstitutional law. This is so well written. As you know, SB 8 effectively bans abortion after 6 weeks of pregnancy, well before many women know that they're pregnant. This ban is a clear violation of a woman's right to choose an abortion prior to fetal viability established nearly 50 years ago under Roe v. Wade. SB 8 also creates a private right of action that allows any individual to sue not only reproductive health care providers that violate this statutory ban, but any individual who aids or abets the performance or inducement of an abortion in violation of the ban, all while specifically prohibiting state officials from enforcing the statute. The private right of action is the law's most insidious feature. It represents an effort by the state of Texas to evade judicial scrutiny long enough for a clearly unconstitutional law to take effect. Indeed, in an unsigned shadow docket ruling late Wednesday, SCOTUS refused to even hold a hearing on the issue presented by this private right of action. Instead, over the dissent of 4 justices, including Chief Justice Roberts, the court denied application for emergency injunctive relief, specifically citing the plaintiff's failure to carry the burden on the complex and novel antecedent procedural questions presented by the law. By accepting the state of Texas's legal gambit, the court thrust the citizens of Texas into a regime that is as unsettling as it is unconstitutional. It awards a bounty, a minimum of $10,000 plus legal fees to any individual who successfully brings suit under the law. In Texas, women may now be reluctant to confide the fact of a complicated pregnancy in a once trusted neighbor or coworker, family members, or any of whom might simply want a payday under SB 8. The perverse system has not only a chilling effect on a deeply private decision-making process that's essential to women's personal autonomy, but is also just plain chilling. And our fears are hardly theoretical. Anti-abortion groups in Texas have already begun setting up anonymous tip lines to allow individuals to report their fellow citizens. Other states are preparing to enact similarly dangerous laws. As Justice Sotomayor wrote in her dissent in the court's ruling, quote, "It cannot be the case that a state can evade federal judicial scrutiny by outsourcing the enforcement of unconstitutional laws to its citizenry. Similarly, the Department of Justice cannot permit private individuals seeking to deprive women of their constitutional right to choose an abortion to escape scrutiny under existing federal law simply because they attempt to do so under the color of a state law. Indeed, the department is fully empowered to prosecute any individual who attempts, under color of any law, to deprive a United States citizen of any rights, privileges, or immunities secured and protected by the Constitution. We were encouraged by your recent statement. The Department of Justice is deeply concerned about Texas SB 8 and that it's evaluating all options to protect the constitutional rights of women, including access to an abortion. 2 generations of women have come to rely on the right to choose an abortion. That choice is deeply private and should not in any way be intruded upon by any third party, let alone a vigilante seeking a payday from the state. We urge you to act to protect the right to choose without delay." And then it's signed by every Democrat here and I'm just looking through here. Joe Nikias, Craig Mondier. Yep, every Democrat in the judiciary. So
cheers and applause. That was incredibly well written.
Yeah, very good. Saying there is current federal law that should disallow this. And we talked to Steve Vladeck yesterday, who says, original jurisdiction and Texas sovereignty doesn't apply. Just saying. Lawrence Tribe also tweeted the same thing. And that's why I tweeted, put on your original jurisdiction pants.
Yeah.
And just try to do something here, Because like I said, if you could put forth that weak-ass argument against Judge Amy Berman Jackson on that Barr memo.
No kidding.
The least you can do is try something here. And it's a better chance. You have a better chance here.